myself. I'm a lecturer and assistant professor at the Civil Law Department, and my topic is about the changes in Ukrainian corporate law with the ratification of the EU-Ukraine Association Agreement. There is a lot of information on this topic actually, so I had to put it in one presentation, and of course I will have to cut some things, and I will be short in some things, of course. But let's start from some basics. Last year, you know that the association agreement was first of all signed on the 21st of March, then it was signed, the economic part was signed on the 27th of June, and then it was ratified on the 15th of September by the Verkhovna Rada and the European Parliament simultaneously. And today we have good news that it is already ratified by all member states of the European Union, with some, according to the information I found, the last ratification was by Brussels Regional Parliament on the 30th of November. And in the Netherlands, for example, there will be a referendum on the 6th of April 2016, which is not binding, so it doesn't matter. So the agreement will take effect, but still they have some doubts about whether it is necessary to have this agreement with Ukraine or not. So about the entry into force and provisional application. Now association agreement is provisionally applied, and it has been provisionally applied since the 1st of November 2014. It also matters because since after the 1st of November 2014, the implementation terms started expiring. So that's why all the directives and regulations that are indicated there have to be implemented already. So, as for company law, well, unfortunately, there will be some boring things because there is a lot of information and a lot of stuff, a lot of details in this sphere. So basically, there is one article in the association agreement which deals with company law, and it concerns three directions. First of all, it's about protection of shareholders, creditors, and other stakeholders, and all the directives and other EU law is listed in the Annex 34 of the agreement. Then we say, then the next part, B, is about accounting and auditing, and it is all the directives and etc. All the EU law is listed in Annex 35 to the agreement. And the last but not least is the development of corporate governance policy, and the acts, the soft law, is listed in Annex 36. Now I will proceed with these annexes to the agreement. So, the first annex is about the protection of shareholders, creditors, and other stakeholders. It contains 10 directives that have to be implemented in Ukraine. So, so basically there are three kinds of directives listed in the Annex 34, and they differ with the term they have to be implemented. The first part of directive, there are three directives, they have to be implemented within 2 years, till the 1st of November 2016. They are old, those are old directives that were even adopted a long time ago in the European Union. They are used to these directives. These are first directive, second, and 11th. And I have to say one thing here, because these are all directives, and the association agreement was drafted between 2007 and 2012, and they were effective at that time. But after it was drafted and provided for ratification and signing, there were new directives already. But the old directives were left in the association agreement. So formally we have to implement all directives, but nobody makes us. I mean, we are allowed to do it with new directives as well, because all the provisions are preserved in this new directive. So this is the first part. The directives have to be implemented within 2 years. Then, the second part is concerns directives that have to be implemented within 3 years. Third, 6 and 12 and shareholder rights directives. Some of them have also been amended or repealed. And then we have the third part of the directives. They are new directives, like takeover directive. They have to be implemented within 4 years. For example, takeover directives. There is a draft law on takeover directive which will be adopted, I believe, quite soon, because this draft law has been amended many times, and there were different laws by Azarov, by Yanukovych, and Yanukovych at some point just put a veto on this draft law because he said that, oh, there is a violation of constitution, etc. But we say that today it will be adopted anyway because it's in the association agreement. So this is what I will not describe in detail. This is about accounting and auditing. This is the second annex, Annex 35. And the third annex is about further development of corporate governance policy. These are soft law, the so-called soft law. And Ukraine has to implement it, but there are no deadlines. I mean, we can do it anytime. So, 1 year has passed after the association agreement was ratified. What has happened during this year? I have selected 5 laws, and some of them are very new. You see, the 24th of November, one law was adopted yesterday. I will briefly talk about every law and how they are connected to the association agreement. So, the first law is about the amending of certain legislative acts related to identification of ultimate beneficiaries of legal entities. This is a very topical issue now. I mean, the issue of ultimate beneficiaries in Ukraine. This, Arseniy Yatsenyuk, when he presented this law, he said that this is the end of offshore era in Ukraine. But of course, maybe it's just words, you know, because in fact companies have to establish ultimate beneficiaries, and according to this law, ultimate beneficiary owns a share or a right to vote in the amount of 25% or more. And if you do not disclose this information to the registration agency, then the director of the company has to pay a fine in the amount of 5,000 to 8,000 hryvnias. Is it a lot? How do you think? Oh, I mean, if it is a company like millions, billions of dollars, and then he has to pay just a fine 8,000. So, but you see, this is the result of this law. What happened after this law? Large queues, because the citizens had to provide this information by 25th of May 2015, and they couldn't. It was not physically possible. So that's why there was some turmoil and unrest, and people's deputies decided to change the law, and they postponed the deadline for 4 months, and also they provided that legal entities may submit information that there is no ultimate beneficiary. So basically, this law had no teeth, and with these amendments, it is even weaker now. That's why we can say that, of course, many companies disclose their information, but still it's not that effective. So, the next one is, I guess, it's a more effective law, which was adopted on the 2nd of March 2015, and it's about disclosure of ultimate beneficiaries by banks. And it introduced the concept of a key owner of legal entity, and which is may own less than 25%, but it has to disclose its information. And now you can see this the process of disclosure and by some banks of their ultimate beneficiaries, real owners. So this law is, I mean, according to the some statistics, it has been more effective than the previous one. This is the law on amending the law of Ukraine on joint stock companies. Well, I've included this picture because it was mostly about Ukernafta, and but this law concerns all companies, all joint stock companies. So, well, Kolomoisky was not happy with this law. It was about the change of quorum requirements, and the change was from 60% quorum to 50% quorum. Now, this law has nothing to do with the association agreement, actually. It was an attempt of the state to collect more money from some state enterprise. Of course, we can understand the state, I mean, in this situation, but still, it provided for some uncertainty, you know? I mean, when you can imagine there are many companies established with 60% with this, according to this requirement, and then suddenly they have to switch to other rules. I mean, this is kind of unstable. And it's already enforced. Then, the most sophisticated law of all, and it does include some implementation of association agreement. Well, there are a lot of words here, so and a lot of letters. So I will just briefly mention some points here. So the derivative action is introduced. Then we have the removal of 100 shareholders, the quantity or the requirement of 100 shareholders in private joint stock companies, and and also more information right for shareholders, which is kind of implementation of a directive on rights of shareholders. And there is also some rules for physical persons, that only physical persons according to this law will be able to be members of supervisory boards, and the concept of independent directors is introduced, which is also directed at protection of some minority of shareholders, and it's the implementation of Commission recommendation on these non-executive and supervisory directors. Of course, and this is the second slide. I compare this law to this big truck. You know, this is really sophisticated, and it was well assessed by some experts in the field. So, I mean, we can say that it's a good law in general. But I know that for example, some insider information that this law will take effect on the 1st of May 2016. According to the first draft, it had to take effect on the 1st May 2015 to make Ukraine higher in doing business rating. But there was one People's Deputy who said that no, it's too early. We have to wait and to adopt the market. And that's why the law was taken with this amendment. We have this, it will take effect in 1 year. And some provisions will apply after the 1st of January 2018. Okay, I will not stop on these provisions, some of them, but in general, I mean, not all of them are fully elaborated, but there are positive things in this law. And a new law, which was adopted yesterday, which is about limited liability companies, the quorum requirement changed from 60% to 50%. Well, the same thing which happened to joint stock companies in the beginning of this year. And we'll see how it hasn't been signed by the president, and we'll see how it goes. But of course, taking into account that there are about more than 80% of limited liability companies of all legal entities in Ukraine, it will have its practical effect. So, in general, we can say that Ukrainian laws have been partly harmonized with EU laws. And these are directives I've listed that have been already somehow implemented. The first directive, second, third, sixth, transparency directive, shareholders. For example, 12th directive has been on single-member private limited liability companies, have been harmonized in the Civil Code of Ukraine. And what's next? Well, nobody knows actually. But we expect further harmonization with EU laws in this sphere. For example, the takeover directive will be sooner or later it will be implemented with the squeeze-out rule. Squeeze-out rule is when, well, you have when a majority shareholder comes and he acquires about 95% of shares, and then he has the right to buy all the shares from minority shareholders. And compulsion. Even if minority shareholders don't want to sell their shares, he still can buy them. And there are also some things which are important in this sphere. First of all, the coalition agreement. If you want to know what will happen next, just check the coalition agreement. It concerns some introduction of shareholder agreements, prevention of rider attacks, and more discretion in relationship between shareholders, and a new regulation with limited liability companies. There is a draft law on limited liability companies. And there is also a complex program of financial sector development till 2020, which provides for more transparency and disclosure in the financial market. So, basically, briefly, this is it, and I will be happy to listen to your questions or any comments, and then we can proceed to the